It's time for IP in the news. So, what are we talking about today?
Okay, so what if you were on a jury and you were instructed by the judge to define what the word beer means? What is beer?
Well, I mean, is that like even a legal question?
Well, so there is a case where Corona has Corona beer. They sued a company that had hard seltzers for trademark infringement. It went to court, and the judge ruled the jury must define beer to resolve the case.
Well, no wonder our legal system is having so many problems and there's so many backlogs, right? If you get cases like that. Is there like a real case here though?
Yes. So U.S. District Judge Lewis Kaplan ruled that Modelo, which is Anheuser-Busch's group, is not entitled to an immediate pretrial win in its trademark case against Constellation. So it also denied Constellation's bid to end the case early last month. So the decision sets up a jury trial that could turn on how the companies defined the word beer in a trademark licensing agreement.
All right. So basically, as I understand it, the case is about whether or not you can call a seltzer a beer, right? And they're in court right now fighting about it.
Famous brand name to describe your seltzer. So there's Corona beer,
Right.
which is Anheuser-Busch's product. And then there's this other company that decided to make Corona hard seltzer. They're both in the alcoholic beverage category. I don't know how they could get away with it.
Right. Okay. So that's the case, right? Because you have two different companies using Corona, one for seltzer, one for beer, right?
Yes.
So what does beer got to do with anything?
Well, they have to define beer because the argument that the other side is making is that
Seltzer is not beer.
seltzer is not beer.
Got it. All right.
So
Well, okay. I mean, you wouldn't think they'd have to go to court over something like this, but I guess that's what companies do. Anyway, Mark, what are your thoughts about this situation? Right.
So I'm gonna play a bit of a different hand here. I mean, first of all, Corona's a terrible name. I mean, I don't know why they're arguing over this because there was this big thing called the virus that happened, and actually beer sales went down because of the coronavirus. And so, if you're setting out to create a brand, why would you go ahead and create a drink using a brand that already exists? I mean, it's going to be harder to rank for SEO. It's going to be harder to get your one seltzer in the minds and the hearts of everyone who's out there shopping. So frankly, this actually just proves that they're arguing over something that they shouldn't even be arguing over.
I totally get where you're coming from. And I have to say, I can't point to any names, but I've been involved in cases where I'm like, this has no business impact. It makes no sense. Why are we doing this? But here we are. So, no, great points. And I think that is really something that we should keep in mind. Mike, what are your thoughts?
Well, I am a great consumer of beer, not a connoisseur, but I think we should define beer. If Coca-Cola can have their formula in a vault, I think we should define beer so people really know.
Right. I mean, this is important. I mean, it's only been around. I mean, beer has only been around for thousands of years. And so it is important that we finally get to the point where we get a legal definition of beer. I agree with you 100%. And Mark, what are your thoughts?
Oh gosh, I mean, I agree with all of them. I think perhaps maybe the easiest way is for everybody to gather around a table, everybody have a shot together, and the last person.
So there you go. Yeah. And that sounds like a beer summit or something, right?
Right.
And then they can work it out in a bar someplace. I couldn't agree more. So.
Yeah. So Kenya.
Yeah.
Yeah, I guess I'm just trying to understand what the end result is of all of this. So based on the definition, what do they expect to happen?
Well, I guess if they define seltzer as beer, they have to stop using Corona seltzer, right? So
I got it. Okay.
And I think given the size of the companies, what they really want is somebody off the market, or they want to force them to change their name, which is why you have all the big legal guns involved here, is because there's already been a lot invested in packaging and marketing. And so they're going to have to change if they want to stay on the market if the court rules against them, right?
Well, it's kind of silly. I feel like what substantiates beer over seltzer? The amount of carbon that's in one versus the other?
Yeah, that's a good point.
Yeah,
As,
or
as a chemist, I can definitely say, yes, beer has more carbon.
well, but doesn't
and more
beer have like
carbs.
hops in it?
Yeah, it's grown from hops. I don't know with all these craft beers, man, I can have anything in it.
It could be anything.
Yeah. So scientifically, they have a good shot of proving their case that they are in fact differently, I think.
Right. But that doesn't mean that they're going to win from a trademark perspective, right? So
Right. They're
we have
both in the alcoholic drinks categories. I don't see how they could possibly say Anheuser-Busch doesn't have a full right here. So it's just my feeling.